A very warm welcome from my side. My name is Lisa Heschel, and I'm the coordinator of the Erasmus Plus project promoting academic freedom in Ukraine. And today we are going to have one of our activities within this framework, namely a lecture in the Ukrainian Voices lecture series. Our project actually aims to support three Ukrainian universities, Odessa International Humanitarian University, Taras Shevchenko National University Kiev, and Sumy State University, in upholding their academic work despite the ongoing war. What we are trying to do is to support them with a series of activities in the field of teaching, in the field of learning, and also in the field of research. And this lecture series, this Ukrainian lecture series, is actually dedicated to Ukrainian researchers, and that they get a voice and that they get a possibility to actually present their work, their research, which is still going on under difficult circumstances, to a wider European academic audience. Today we are going to have the 8th lecture within this lecture series, and it is a very great pleasure to welcome, I have to move a little bit here so that you can see as well, to welcome Professor Svitlana Andrijenkovic with us, who is going to give us a special lecture on the Special Tribunal for the Crime of Aggression against Ukraine toward justice and accountability. And it is a particular pleasure to have Svitlana today with us, because Svitlana actually joined the University of Graz in the beginning of February 22 on just a normal regular scholarship. She came to Graz in the beginning of February, but before she could actually really dig into her research here at the Human Rights Center, events unfolded as they did. The Russian aggression started, and Svitlana had to go home and bring her children to Graz. She is here with us in Graz ever since, and we are very happy that we actually got the possibility to also give her an opportunity to join our staff as a project team member. She's one of the pillars of the project. She's doing a lot of management work. And it's just one of these expressions how European Union programs can actually have a real impact, and how our objective of promoting academic freedom really reach people and really can have an impact on their lives. So thank you for being with us, presenting your work. Svitlana just published a monography on the topic in Ukrainian. Unfortunately, we're trying to convince her to translate it into English to make it available to a greater, wider public. And this lecture will also be recorded and then uploaded on our project homepage. So all lectures in this lecture series are made publicly available. And so it's recorded now. However, for the Q&A session in the end, the recording will stop, so that then please feel free to ask whatever you want. So Svitlana, the floor is yours. Thank you very much.
Thank you very much, dear Lisa and dear colleagues. It's a great pleasure for me to present today on a very important topic that is deeply important for Ukraine and highly relevant for international law. And my lecture is structured in three main blocks. First, I will discuss the current stage of the establishments of tribunal and why existing international as well as national mechanisms are not capable to ensure accountability for the crime of aggression against Ukraine. The second section, I will discuss why it was necessary to create a new legal model for the tribunal for the crime of aggression against Ukraine, and which models were proposed, and why it was enough, and why there were failed difficulties to introduce these models. And the third section, I will talk about interaction with ICC, about jurisdiction of the tribunal, about question of personal immunity and trials in absentia, why it is so essential for the prosecuting of the crime of aggression that is defined as mother of all crimes. The ongoing unprovoked aggression of the Russian Federation against Ukraine continues to cause severe suffering to the Ukrainian people, and it has led to numerous and serious violations of international law, including the systematic deliberate killings of civilians. On one of these pages of these photos, you can see the destroyed residential building. It was destroyed yesterday in city Ternopil. It's the west part of Ukraine. And as a result of this, at least 26 people were died, including 3 kids. And today, on the 20th of November, it's World Children's Day. And unfortunately, 1,000 mothers in Ukraine will never see their kids. The consequences of these aggressions go far beyond Ukraine itself. They affect international community. The Russia aggression was condemned by the United Nations General Assembly in its resolution of 2nd of March 2022, titled Aggression Against Ukraine. This resolution clearly stated that Russia's actions violate Article 2, Paragraph 4 of the United Nations Charter, which prohibits the use of force against sovereignty and territorial integrity of states. At the very beginning of the full-scale invasion, the idea of establishing a tribunal seemed unrealistic to many. However, over time, it has gained broad support from a wide range of actors in such international organizations like Council of Europe, NATO, OSCE. It has also been strongly supported by numerous individual states as well as academic and expert community. And today, this initiative reached the final stage of its practical implementation. Since January 2023, the core group met regularly to work on the development of an appropriate legal framework for special tribunal. The core group brought together senior legal experts from about 40 states, working closely with Ukraine, Council of Europe, and EU's legal services. In May 2025, the work of the core group was declared completed with the finalization of special tribunals fundamentals documents, namely bilateral agreement between Ukraine and Council of Europe on the establishment of the tribunal, statutes of the tribunal, which is integral part of this agreement, and enlarged partial agreement on the management committee on the special tribunal. On the 25th of June 2025, Ukraine's President Volodymyr Zelensky and Secretary General of the Council of Europe, Alan Berset, signed the historic agreement to establish a special tribunal for the crime of aggression against Ukraine within the Council of Europe. This marks the first time in history that a dedicated tribunal is being established to investigate and prosecute the crime of aggression. This tribunal represents a revolutionary step in international criminal law. Its concepts combine traditions and modern standards of international law. On the 15th July 2025, Ukrainian Parliament ratified this agreement. However, the agreement to establish special will enter into force. The conditions set out in Article 9 of the agreement are fulfilled, in particular after the conclusion of the enlarged partial agreement on the management committee of the special tribunal. Management committee will be a governing body that will select judges, select prosecutor, select presidents of the tribunal and other staff. Why is the enlarged partial agreement needed in the context of establishing the special tribunal? This agreement is needed because without it, the whole process could simply get stuck. In the Council of Europe, many decisions require all states to agree, and not all of them support Ukraine and support the creation of the tribunal at the same time. And thus, and this could delay the tribunals for a year. The enlarged partial agreement allows to countries that are ready to move forward to the creation tribunal without anonymous support from all Council of Europe's member states. So it prevents the process from being blocked and make real progress possible. The key importance of enlarged partial agreement is that it gives other states as well as international organizations way to join the tribunal. European as well as non-European countries and organizations will be invited to sign enlarged partial agreement to confirm their participation in the tribunal. So parliaments of this country should ratify this agreement or other way to join without ratification. It depends on the national legislation. To further strengthen the tribunal's international legitimacy, enlarged partial agreement allows not only for European and non-European countries and organizations to join the tribunal and be members, but also be an associate members of the tribunal. The enlarged partial agreement is a specific form of agreement that exists only within the Council of Europe, and this provision helps overcome the procedural delays that often block international initiatives. So, reserve to use this agreement is not only a procedural step, it is a strategic tool by allowing flexible participation, overcoming diplomatic deadlock, and it turns special tribunal from ambitious idea to the real instrument. So the establishment of tribunal follows a step-by-step approach. After the conclusion of the enlarged partial agreement and once sufficient contributions are received for funding tribunal's creation, the management committee will launch the first stage. The first stage will take place without exercising jurisdiction, and during this phase, the management committee will select judges, select president, select prosecutor. The second stage will begin after the host state agreement with Netherlands will enter into force. Now all efforts are focused on concluding enlarged partial agreement as soon as possible. So we can truly see, like before our eyes, a new international body is being formed, a new mechanism that will deal only with the crime of aggression. Why it was necessary to establish this tribunal? Why is International Criminal Court not sufficient? Or is there any mechanism in the world that can deal with the crime of aggression against Ukraine? Also, there are existing mechanisms to prosecute war crimes, crimes against humanity, genocide. None of them can currently hold top military and political leaders accountable for the crime of aggression against Ukraine. And prosecuting war crimes as well as crimes against humanity cannot replace accountability for the crime of aggression. And the creation of the tribunal seeks to fill these gaps in international justice. In national courts, top officials, the so-called Troika, its head of state, head of government, and Minister of Foreign Affairs, they are protected by personal immunity from the exercising foreign criminal jurisdiction. So it's not possible to prosecute them. The proposals was also to amend Rome Statute so that ICC would have the same jurisdiction over the crime of aggression as concerning other 3 core crimes. But the ICC Assembly of State Parties were meeting at special session in July this year, so Kampala 2, and for now this issue has been postponed. In any case, any amendments now would not solve the problem of ICC's lax jurisdiction over the crime of aggression. Why? Since they would not apply retroactively. Therefore, a need arose to establish an international criminal tribunal for the crime of aggression. And now I will turn to the question of legal model that was chosen for this tribunal. Different legal models were proposed for the establishment of the tribunal. Ukraine and several states supported the idea initially that it should be tribunal created through the agreement Ukraine and United Nations. But states J7 preferred an internationalized tribunal established under Ukrainian law, but with international elements, for instance, international judges, like special extraordinary chambers in courts of Cambodia or Kosovo specialist chambers. Both models faced challenges. For the first model, agreement between Ukraine and United Nations, it was a question whether the United Nations General Assembly will have political support or have the legal authority to work or to do instead of United Nations Security Council. Concerning the second option for the internationalized model, the problem was that Ukrainian constitution does not allow to create special courts and does not allow to have foreign judges. And another problem that during martial law, it's not possible to make amendments to the constitution. And anyway, if a tribunal would be created under national law of Ukraine, personal immunity still would apply before the national criminal jurisdiction. So, as a result of extensive consultation and discussion on the legal mechanism for establishing the tribunal, an optimal compromise model was developed, namely Council of Europe model. Parliamentary Assembly of Council of Europe proposed establishing a special tribunal through agreement between Ukraine and Council of Europe, supported by enlarged partial agreement, open to non-member states of Council of Europe and international organizations. So this is the most realistic option in terms of both legally basis and political legitimacy that clearly falling within the Council of Europe mandate. This model is based on the flexibility and adaptability of international law. The main focus has been to make sure that international tribunal is legitimate, created in line with international law, supported by respected international organization, includes representatives from different legal systems, and has its own international legal personality. The tribunal will have the status of international body, so not national or hybrid structure. There is no clear rule in international law on how many states need to make a tribunal international, or how exactly they should express their common will. So the position of the international community can be expressed in different ways through the United Nations and international organization, or through the regional organization that is Council of Europe. The international character and legitimacy of the tribunal is ensured by creation in accordance with international law, application of international law. The statute has a high level of legitimacy supported by at least 40 states and oldest human rights institution. The current membership of Ukraine and former membership of Russia in this organization that accepted obligations under the statute. The possibility of non-member states and international organizations to join, and independent prosecutor, involvement of international judges. So the composition of tribunal should be as representative as possible, as should not be regarded as a Western project, to ensure that this tribunal has impartiality. An important question concerns the way in which the special tribunal will interact with the ICC. The special tribunal is considered to complement ICC, and it is expected that two institutions will conclude agreement and to ensure their mutual coordination and support. Special tribunal should not overlap with ICC. It should only work as temporary way and deal with limits of ICC jurisdiction concerning the crime of aggression against Ukraine. The statute of the tribunal sets out 3 guiding principles that define how special tribunal and ICC should relate to each other. First, special tribunal should cooperate with ICC on all matters of mutual concerns. It may conclude agreements and arrangements between two organs to ensure effective exercise of their respective jurisdiction. Second, state parties to the ICC should not use the cooperation with tribunal as pretext not to fulfill their obligation under the Rome Statute. And third, the tribunal must give priority to the ICC only when a person subject to an arrest warrant by the ICC is currently detained in the detention facilities of the ICC. In all other situations, the special tribunal may proceed with its cases even if the ICC is investigating the same person for the crime under its own jurisdiction. The next important issue to address is the question of special tribunal's jurisdiction. The special tribunal's jurisdiction have the power to investigate, prosecute, and try persons who bear the greatest responsibility for the crime of aggression against Ukraine. And now we will speak about ratione materia jurisdiction. That means that the tribunal is powered to deal with only one crime, the crime of aggression against Ukraine. The definition of the crime of aggression is contained in Article 2 of the statute. This statute applies a mixed and new model, Strasbourg model of the crime of aggression. Definition of crime of aggression in this statute is based on the wording of Rome Statute and the provisions of Statute of International Military Tribunal of Nuremberg. So crime of aggression means the planning, preparation, initiation, or execution by a person in a position effectively to exercise control over or to direct a politically and military action of state of an act of aggression, which by its character, gravity, and scale constitutes a manifest violation of the United Nations Charter. This definition reproduces the wording of Article 8 bis of the Rome Statute. The statute of the tribunal also refers to the specific situation in Ukraine. Article 2, paragraph 4 clarifies that any act of aggression determined by the tribunal to constitute a manifest violation of the United Nations Charter shall also be considered a war of aggression. This formulation makes it easy for states to support the tribunal without having changes their position on the Kampala Amendment. And the concept of war of aggression was taken from the statute of the Nuremberg Tribunal. This approach allows to the tribunal to apply a most updated definition of the crime of aggression that is suitable for concrete situation of crime of aggression against Ukraine with alignment with United Nations General Assembly resolutions. Concerning jurisdiction ratione loci of territorial jurisdiction. This jurisdiction is based on the territorial jurisdiction of Ukraine. It covers acts that were initiated abroad but completed on the territory of Ukraine, that is, acts committed against Ukraine. The territorial jurisdiction is based on the extended interpretation taking in account the cross-border nature of the crime of aggression. The recognition of the act of aggression by UN General Assembly provides a legal basis for extending tribunal's jurisdiction to all actions regardless of where they were committed. Ratione temporis jurisdiction is not explicitly defined in the statute since there are no clear temporal limits and different interpretations are possible. So two main interpretations. First approach is narrow approach, and this approach would limit the tribunal's jurisdiction to act connected after the full-scale invasion in 2022. A broader approach would extend jurisdiction to acts related to occupation of Crimea and acts of aggression starting from 20th of February 2014. And this view is supported by indirect reference in Article 2, Paragraph 3 of the statute to United Nations General Assembly resolutions that were adopted since 2014. However, a very positive solution was found. The tribunal has authority to determine its own temporal jurisdiction as long as the acts in question meet the definition of aggression under Article 2 of the statute. The statute establishes a legal mechanism under which, if the Prosecutor General of Ukraine submit a request to tribunal to investigate the involvement of the Russian official who was participated in aggression since 2014, such a request would open the door for the tribunal to recognize such acts as aggression since 2014. So, in other words, this is indirect mechanism. Instead of explicitly stating 2014 in statute, it allows for tribunal to determine this date itself through a concrete case. Next type of jurisdiction, ratione personae jurisdiction, defines who may be held personally accountable before the tribunal. So who they are, the future defendants of the special tribunal. Ratione personae jurisdiction is defined through a two-level approach. First, person capable of effectively exercise control over or direct the political or military actions of the state. This provision reflects the provision of Article 8 bis Rome Statute. Second, persons who bear the greatest responsibility for the crime of aggression against Ukraine. The statute confirms that the crime of aggression is by its nature a leadership crime, and the concept of persons bearing the greatest responsibility narrows the personal jurisdiction of the tribunal. So it will focus only a limited group of most influential individuals who has actually capacity to initiate or conduct act of aggression. One of the most challenging issues in the process of establishing the tribunal was the question of immunities and whether high-ranking officials of the aggressive state can be held accountable. In international law, there are two categories of immunities: personal immunity and functional immunity. Personal immunity of incumbent high-ranking officials, so-called troika, state of heads, states of governments, and Minister of Foreign Affairs. So personal immunities protect these officials while they are in office. It means that foreign states cannot prosecute them, cannot arrest them, or otherwise interfere with their person or property during their term in office, regardless of seriousness of their conduct. Functional immunity applies to acts carried out by state officials in their official capacity. So it protects the official action from being prosecuted in foreign courts. Overcoming personal immunities of the top political and military leadership of Russia has become a complex political and legal issue, and serving as key obstacle for the establishment of the tribunal. From the very beginning, Ukraine argued that there should not be immunities at all. But many key partners had a completely different view. Therefore, it was necessary to make a compromise. The statute of the special tribunal contains a provision excluding the invocation on immunities, personal and functional. We can find this provision in Article 4, Paragraph 2 of the statute. Regarding functional immunity, according to Article 23, Paragraph 4, functional immunity does not apply before the special tribunal. Regarding personal immunity, Article 23, paragraph 5 of the statute contains a finely crafted procedural provision with respect to the personal immunity of Troika. If the prosecutor's indictments concern head of state, head of government, or Ministry of Foreign Affairs, pre-trial judge will not confirm this indictment, but will suspend all proceeding will be suspended until that person is in office. Or as an option, if state formally waives the immunity, but for now it's not possible. So, in other words, this article establishes a temporal procedural safeguard. The tribunal acknowledges personal immunity while the person holds office, but still has the right to reopen these proceedings once the immunity no longer applies. So, this solution was adopted after a long and complex negotiations, which at one point brought the entire work of the establishing the tribunal to a deadlock. Consequently, the provisions of the statute demonstrate that international law continued to evolve and that personal immunity no longer the guarantees of lifelong impunity. The practical question remains. Once immunity no longer protect an accused, how can they be physically brought to the tribunal if a tribunal cannot reach physically these persons? This is why trial in absentia became a realistic and necessary tool for secure accountability. At the beginning, the key countries involved in the tribunal's negotiation opposed the idea and insist only on holding in-person trials. But Ukraine and its partners managed to convince that trials in absentia is essential, because without trials in absentia, the tribunal would not work. From a human rights perspective, conducting the criminal proceedings in the absence of accused is not prohibited. The European Court of Human Rights recognized such proceedings as lawful, provided that procedural safeguards are respected. And to enhance the effectiveness of prosecution, the statute of the special tribunals allowed for in absentia proceedings under certain conditions. That is, when such procedures are legally justified and practically necessary. So it's provided the right to be informed of the indictment, hearing and consequences of absence, the right to legal representation, the right to a trial, or the right to waive this right. Proceedings in absentia constitute more than a political signal. They represent a legal, justified mechanism with tangible legal consequences, including restriction on the mobility of the accused, political isolation, and preparation for potential future change of power. And the very fact of verdict is important as it turns the Russian top leaders into internationally recognized criminals. Realistically, Russia is very unlikely to hand over its top leader to The Hague, but this should not stop justice from being served. And in conclusion, international legal vacuum regarding the prosecution of Russia's aggression highlights the need to develop a new accountability mechanism for those responsible for the crime of aggression, alongside advocating for a broader reform concerning amendments to the Rome Statute. As with any other international criminal court, the effectiveness of this tribunal will depend on cooperation on states and international organizations, in particular in providing legal assistance or transferring individuals. You can write anything on the paper, but if there is no political will, it will be no results. there is a criticism regarding selectivity or double standards. Some argue that the very idea of establishing a special tribunal is selective, and asking why the world pays special attention to the crime of aggression against Ukraine, because there are a lot of other acts of aggression, such as Syria, Iraq, and they went unpunished. Others believe that it would be better to reform the ICC rather than create a new tribunal or express concern of possibility overlap between two courts. Indeed, the failure to hold those who started war in the past accountable is sad reality, but yet the efforts to achieve justice for the crime of aggression must begin somewhere. Russia's invasion in Ukraine was one of the most blatant acts of aggression in the past 80 years, and this provides a crucial opportunities to start that process. Russia's war aggression against Ukraine is different from the conflicts in Iran, Iraq, or Yugoslavia, as in this case, one member of Council of Europe invaded the territory of another member state. This very fact justifies that Council of Europe, which statute calls for strengthening of peace in Europe, focus on prosecuting this war against common European values. Victims in countries like Syria, beyond doubt, deserve justice no less than victims in Ukraine. However, the current inability to achieve a perfect justice should not be a reason to reject steps toward justice that can be taken now. And the best way to make international justice less selective is to demonstrate that international criminal mechanism can deliver justice impartially. And if this crime of aggression goes unpunished, it would be some Rubicon that this crime would not be unpunished and further. It is vital to ensure that Ukraine does not become another unpunished victim of aggression, and the tribunal is a legal and moral duty before the victims of these aggressions.
So